going to be addressing us, didn't you, Mr. Collins? But I think, having read the papers, we will be more assisted by hearing from Mr. Warnock first.
My lords, my lady.
If you, we will understand, despite your seniority and professionalism, if you want a second to regroup but you're probably ready to go.
I'm ready to go. My lords, my lady, below two judges, one of them, experienced, designated civil judge, took the view that it was desirable in this litigation that the dentists, as I shall call them, the four additional defendants, should be joined as defendants to this claim. Both considered they had the power to do so, and that's the short issue which arises on this appeal. We submit that the answer to the question as to whether they had the power to exercise that discretion is, in terms of the civil procedural rules, yes, we submit the power undoubtedly does exist. My lords and ladies have the CPR in the authority bundle, the relevant sections from them. And at tab 1, one has 19.2, which sets out that at subparagraph 2, the court may order a person to be added as a new party if it's desirable to add the new party, so the court can resolve all the matters in dispute in the proceedings, or there is an issue involving the new party and an existing party which is connected to the matters in the dispute in the proceedings, and it is desirable to add the new party so the court can resolve that issue. And as I will come on to in a moment, the courts have said that those provisions are to be interpreted very broadly. Then, in terms of the procedure for adding or substituting at 19.4, it's made plain at 19.42 that an application for permission under paragraph 1 may be made by an existing party or by a person who wishes to become a party. And we do draw attention to the breadth of an existing party. One exception is set out to that at subparagraph 4, which is nobody may be added or substituted as a claimant unless he has given his consent in writing and that his consent has been filed with the court. Now, the rule is accompanied by a practice direction, which is at tab 2 of the bundle. And at subparagraph 1.1, it sets out that parties may be removed, added, or substituted in existing proceedings, either on the court's own initiative or on the application of either an existing party or a person who wishes to become a party. Importantly, at 3.2, where the court has made an order adding or substituting a defendant, whether on its own initiative or on application, the court may direct, one, that the claimant is to file with the court within 14 days or as ordered, an amended claim form and particulars of claim for the court file. 2, a copy of the order to be served on all parties to the proceedings and any other person affected by it. 3, the amended claim form and particulars of claim, forms for admitting, defending and acknowledging the claim, and copies of the statement of case and any other documents referred to in any statement of case to be served on the new defendant.
Just as a matter of interest, Mr. Warnock, how is the claimant meant to plead this claim?
Well, in a sense, my lord, we say it's already pleaded.
By whom?
By the claimant. You'll see, and I'm going to take you to a passage in the district judge's judgment in a moment, but there was some discussion, it seems, in the court below whether, in fact, any amendments were needed to the particulars of claim, and the view was taken that they probably weren't.
So that there's no ambiguity about this. Your case is that the effect of this judgment, the appeal judgment, is that the claimant is obliged to plead not only that the dentists were negligent, but that she wants to recover from them.
Yes. I have to.
But what if she doesn't want to recover from them?
Well, that's not the test under the rules. The reason I drew attention to
But
this...
it is the question my Lord answered.
Yes, if I may come back to it. But can I say why I took you to 3.2 to begin with? Because, my Lord, it's what addresses the particular concern that my Lord Underhill, or Lord Justice Underhill, had in the Beresford case, which was that a judgment in favour of the claimant would be devoid of content in relation to the application of the rules under the employment rules. Here, such a judgment would not, in fact, be devoid of content because the practice direction specifically provides that the court can require service of an amended claim form. Indeed, it can require service of an amended particulars of claim. And more than that, it actually provides for provision for service of documents, for the acknowledgement of service, and for the choice to admit or defend the claim. And in answer to my Lord's question about why should the claimant have to sue someone she doesn't want to, the answer is it's looking at the litigation not just from the claimant's perspective, but from the perspective of what courts consider the best way of case managing the case.
You can't call it case management to make someone sue someone they don't want to sue. It's fundamental.
Well, in reality, the differences here are a rather fine one, because if the defendants, for instance, had chosen to use Part 20, the reality of the situation is, but with the defendant stuck as piggy in the middle.
But that's what should have
Not
happened.
necessarily. Not necessarily. When someone's joined as a Part 20, a claimant has a choice, and whether to say, oh, well, now they're in, I'll sue them as well, or not. Sometimes they do, sometimes they don't.
Yes.
And if they don't, they still have no claim. The Part 20 defendants may then be in the litigation, but the claimant may not assert any claim against them. It's entirely between them and the defendant and the third party.
That is absolutely correct. The distinction, I submit, is a rather more subtle one, which is that if the dentists were brought in by Part 20, the claimant would face, in fact, exactly the same cost risks in relation to them. I've set out in my skeleton the relevant passage from the White Book on that. What the claimant gets by bringing them in now, or being required to bring them in now, is no real disadvantage. But, in fact, whether she wants it or not, she's in a better position in that if the claim does fail against my clients, she's left with the claim against the defendants. And, of course, what weighed quite heavily, it seems, with the judge below was a concern that if the claimant does not succeed in the claim against my client, there was a real risk that she would try again against the defendants. The judge recorded that in his judgment.
But, I mean, that would be hopeless. Because, and can I give you notice of my next question?
Yeah.
Which is, I'm not going to ask you how to draft your Part 20 proceedings, because we can all do that in about 45 seconds. But how is the claimant going to formulate her Section 33 application?
Well,
you don't have to answer that now because you're on a slightly different point, but it goes exactly to the same question, because the district judge has left this over to trial, and you know the terms of Section 35 and so on and the rules. She's got to explain why she didn't sue them in time, and the answer is going to be because I decided I didn't want to sue them.
yes. I suspect it's not an application that detained the trial judge terribly long, since the dentists themselves opposed her appeal before the judge and consent to their joinder. But the answer is, in relation to Section 33 applications, they're dealt with in a range of ways. I mean, sometimes they're dealt with by oral application, but it wouldn't take much in relation to the Section 33 application.
But they may not have opposed being joined, but there isn't a doctrine of relation back to applicable to that.
No.
So they're joined as from the date of, well, I think they're joined under Rule 3. Under paragraph 3.3. They're joined as from the date of service of proceedings on them.
Yeah. Yes, and then their joinder relates, well, subject to the exercise of the Section 33 discretion.
Okay, but your earliest possible date would be the date of order of the joinder.
Yes.
They are clearly outside. She's clearly outside the primary limitation period against them.
For some of the allegations, yes.
Most of them, up till at least 2016. She's not going to succeed. I mean, it is of course possible that no one raises limitation at any stage, but that would be almost unique in my experience. Which is,
I mean, the fact that there isn't a need for a Section 33 application is something that the judges below clearly took into account when exercising their discretion, and what weighed with them was they weren't satisfied, it seems, with the answer they had from the appellant's counsel, that there wouldn't, or that the appellant's counsel were unable to say that there wouldn't be a Section 33 application in any event. And that seems, so that what I say is that it is an issue. It's an issue which goes to the exercise of the discretion. It may be, it's not a terribly real issue in this case, but it's an issue which the judges below clearly took into account when deciding whether to exercise their discretion in relation to the joinder.
sorry, I think you were on paragraph 2.2 when...
Yes, I was on paragraph 3.2 of the practice direction. And I was submitting that in relation to the Beresford case. This is a distinguishing feature because the wording of the CPR is in fact different from the wording under the employment rules in any event. But here you actually have the relevant provisions envisaging a situation where there would have to be an order for an amended claim form and particulars of claim, and amended service of forms requiring admission or denial of those claims. And in relation to what the district judge ordered in this case at page 132 of the bundle,
Sorry, the page number again?
page 132.
Thank you.
She in fact made an order in those terms. First of all, paragraph 2, the claimant was to file an amended claim form. And I'll come on to the reason for any amendments to the particulars of claim in a minute. And then at paragraph 4, the amended claim form and the amendments to the particulars of claim were to be served with forms for admitting, defending, acknowledging, and so forth. In relation to the particulars of claim, on page 130, at paragraph 33, you'll see that there was apparently some discussion at the end of the hearing in relation to adding the 4 dentists as parties, giving directions for a brief period of time to make any amendments to the statement of case if so advised. We have discussed that it may be fairly limited, if none at all. The reason for that is that if one goes to the particulars of claim at page 134, sorry, 134 is the claim form. Particulars of claim begin at 136. In essence, the claim against the defendants, well, it's already the claim against the dentists is already fully pleaded. That runs on to page 165. In fact, the only allegations that specifically raise issues against
I'm sorry, it's obvious, but it's bringing out. You say the case against them is fully pleaded. You mean the allegations that their treatment was negligent is fully pleaded?
Yes. Also,
but there is not a claim that they owed any duty themselves or were in breach of any such duty. Or I suppose so. You're probably right. You better see how it's pleaded. I suppose if it's how's the duty pleaded?
Well, it's pleaded at paragraphs 3 and 4 against my clients, but it includes the plea of vicarious liability at paragraph 4 for breach of duty or negligence on the part of the dentists. And then at
yes, I see. Yeah, no, you're quite right.
and in terms of the particulars of negligence, it said at paragraph 65 that the care of the claimant by the defendant's clinical staff was negligent.
65.
Yes.
Yeah.
And there then follows some 120 of allegations of negligence. I accept, in fact, as it happens, no amendment to the particulars of claim would be needed in relation to causation and loss because it's simply put as by reason of the matters aforesaid, the claimant has suffered loss, injury and damage. And so, in fact, the district judge is probably right, or those before her were probably right, the particulars of claim itself probably doesn't need any significant amendment, but undoubtedly the claim form would have to be amended to add them as defendants.
Yes.
Well, I'm not sure that's right, because although you can say there's an implication of a pleading of duty from the fact that it said that the failure to exercise reasonable care, which constitutes a breach of the non-delegable duty, is pleaded as negligent, you would have to amend the particulars claim. You'd have to add the dentists.
You would have to, certainly that would have to be done.
You would have to identify which dentist is which defendant, so that the allegations are clear as against it. It isn't difficult to do, but you'd have to do, and you would have to say in the prayer that you want it from everybody.
Yes, I think that must be right.
So,
I mean, in a sense, amending the particulars of claim is a less. It's not a significant exercise, and in terms of principle, once one's accepted the principle that one has to amend the claim form to join them, it's perhaps of less significance.
I certainly accept it's not difficult.
We've referred in our submission and our skeleton argument to the fact that there certainly is no general principle that defendants cannot be added against the claimant's wishes, and we referred to the Davis case in the Court of Appeal.
When you say there's no general principle, it's Justice Trulson says there is, and if you're going to say the Davis case establishes that he's wrong, you need to take us to it.
Yes, I'm going to.
Oh, sorry.
I was just merely introducing it.
I'm sorry. For a moment I thought you were skipping over.
What we say about Mr. Justice Coulson, as he then was in his judgment in the Virador case, is that it's not apparent from the judgment that the provisions of the rules or the practice direction were actually cited to him. It's not something that he necessarily had to consider in his case, because in his case there was simply no matter of potentially even an issue between the claimant and the added defendant, who was a party the claimant had no previous relationship with.
But there's no such issue here either.
Well, there is in the broad
sense.
in the broad sense.
Sorry, I shouldn't tease you. Yes, but that is the point. There's only an issue if someone wants to claim against you.
Well, can I take my lord and lady to the Davis and Department of Transport and Trade and Industry?
Yes, that would be helpful.
It's at tab 3. And this case arose out of was one of the various disputes arising out of the coal mining litigation against what was formerly British Coal, now the Department of Transport.
Department of Trade.
Department of Trade, sorry. Yes, Department of Trade.
Yeah, they took on all the liabilities.
Yes.
Yeah.
And the background was that the solicitors acting for the miners in relation to this litigation had applied for a group litigation order in relation to chronic knee injuries. So the case was still at a very early stage, but what they sought was determination of liability and issues related to that liability solely involving the Department for Trade and Industry. And a group of contractors who had employed some, potentially, but not all of the claimants, the CMC applied to be joined in. The judge below considered that he had, it was His Honour Judge Grenfell, considered that he had had the power to join them, but decided against exercising his discretion to do so. The Court of Appeal considered that he had indeed had the power, but were not prepared to interfere with his exercise of discretion on the issue of whether he should do so. At paragraph 3 of the judgment, it's reported in the 2007 first volume of the Weekly Law Reports at 3232. At paragraph 3, Lord Justice Waller referred to the fact that proceedings subject to the group litigation were likely to be against the DTI alone, gives rise to the issue in this appeal during the relevant period over which it will be asserted by miners that they contracted chronic knee injury. British Coal employed contractors to fulfil many tasks in the mines. The contractors who have formed a group known as the Coal Mining Contractor Company, CMC, themselves employed individual miners, and many miners were, during the relevant period, employed both by British Coal and such contractors. The claimant miners, according to those representing the present 5, do not intend to join any of those contractors as defendants in the proceedings. And their primary reason for not seeking to do so is because their advisors take the view that they have a case against British Coal, whether British Coal was employer or not, and because of the increased costs and the risk as to costs which will be incurred if such contractors are joined, similar to the position of the claimant here.
With the exception that Davey is talking about a GLO. So whether or not whether or not the rule permits the power, where you've got your arguments, and one can see that. Certainly, my experience is that GLOs change the game, because the whole point about a GLO is that the court is being asked to create a structure where all issues that are going to arise are brought into it. And that, to my way of thinking at the moment, sets a completely different field to what you've got here, which is a claim by one individual, against a dentist's practice. With no wider implications. It's not as if you're trying to set up a GLO.
But in some ways, I would submit that the difference ought to make it easier in a case like ours, because the point of the GLO is one still has to end up with, usually it runs with, one selects a number of test cases, but there is still there's a generic particulars of claim. Quite often there's then a shorter form particulars of claim. There still ultimately has to be a determination of liability. against someone. It's just that you have it, as my Lord rightly says, in a very large number of cases. And what one seeks to do is identify common issues across those cases and test cases to try them out. And
But the one thing that the court can't contemplate in a GLO is having another GLO afterwards. I mean, that is
no,
both,
it has
both
happened.
It does happen, but both for counsel and for the court.
Yes.
That's the prime consideration.
Yes.
What we have here, if you take the conventional course of Part 20ing them, that simply doesn't happen. If you don't Part 20 them, that's your lookout. Whether they would have an argument against you if you tried to sue them later is a different matter. You've got the benefit of the 2-year limitation period under the Act. So I'm afraid I'm still in the position that the fact that it's a GLO seems to me to change everything.
Well, it may in relation to the exercise of discretion, but can I take my my lord to my lord and lady to what this court said about 19.2, because ultimately that was still what the joinder would have to be under. And at paragraph 7, I should say, first of all, it said the claimants resisted any broadening of the issues and resisted any idea that the CMC should be involved in any trial establishing the liability of the DTI. That resistance was based on a fear as to the way in which a trial would escalate if the CMC or any member company sought to argue points in employer liability which were being fought by the DTI in any event, or B, if the DTI and CMC or any other member company were to fight in the main trial issues relating to the extent to which one or the other of them had responsibility as employer or occupier of the mines, or C, the complex contribution or indemnity issues which arose in the chronic knee litigation Part 20 proceedings. The resistance was also based on the increased risk as to liability for costs if the CMC or any member company were joined as defendant in addition to the DTI. And at paragraph 11 of the judgment, Lord Justice Waller set out the provisions of CPR 19.2, and they've not changed. And then at paragraph 12, he said that 19.2 seems to provide a very wide power to enable parties who may be affected by a finding in any proceedings to be joined. That the power was intended to be wide is supported by the paragraph of the practice direction quoted by the judge in a passage in his judgment set out below the practice direction that I took the court to a few moments ago. The matter remains within the discretion of the court, but in my view, if a minor brought proceedings against the DTI where the minor had also been employed by a CMC member, and where the likelihood was that at some stage the DTI, if found liable, would pursue that CMC member on a Part 20 claim, the court has the power under 19.2 to allow the CMC member to be joined. I emphasise that it would be a power which the court would have the discretion whether to employ or not, and accordingly I do not suggest a CMC member would have the right to be joined.
Can I just ask two questions about that paragraph? One, is it ratio or is it obiter? It might be thought that he is, as it were, conceding the point and going on and deciding it on the discretion issue.
I would have to accept that it's not ratio because, in fact, the court went on to hold that there were no grounds to interfere with the judge's exercise of discretion. Nonetheless, it is fairly powerful ratio from a court which whose members, including Lord Justice Waller, had quite considerable experience of personal injury litigation.
Certainly. The second point perhaps matters less, but with all respect to Lord Justice Waller, isn't it slightly loosely expressed there? If there's a power at all, it can't be affected by whether there was a likelihood that the CMC member, that the DTI would pursue the CMC member on a Part 20 claim. So when he says, and where the likelihood was that that would be the case, that's not, the existence of the power can't depend on that if you're right at all. That's simply a matter that would be relevant to whether it was a good idea to exercise it. Or am I missing something?
My understanding of what he's doing is he's pointing to the breadth of the power.
Well,
And
it's a bit more than that, isn't it? Because in the second line of paragraph 12, he says the power is to enable parties who may be affected by a finding in any proceedings to be joined. So in our case, absent an application under Part 20, the dentists are not going to be affected because there's no claim against them and they're not going to have to put their hands in their pocket or speak to their insurers if they are insured. In order to get them within the affected by a finding, what the judge had to do here was say, however, they are potentially affected because there's a likelihood that at some stage the DTI may pursue a claim.
yes, what was enough was the fact that there could be further proceedings that brought them in, because the judge, or Judge Grenfell in this case, clearly thought that there was a real risk that the DTI would then bring proceedings against the dentists, and the DTI would then point to, look at all these findings that have been made in the main action, and whatever the strict position about res judicata, the reality is the die would be cast for the CMC.
So really what this is saying is the exercise of the power that relies on the court considering the likelihood of some ex post facto application under Part 20 being made once liability had been sorted out, because otherwise they're not affected.
Well, under Part 20, or as this, in our case, our court considered, the judge clearly considered that there was a real risk of a later application against the defendant, against the dentists by the claimant. So the point is the risk of future proceedings was a factor.
If you can then define how you say the test is, you're saying affected by a finding in any proceedings to be joined by reference to the likelihood of future...
Well, no, it's the fact that you haven't... Well, there are two issues. Firstly, the fact that you have a potential interest in the outcome of the proceedings. You may be affected by them, because it's a very wide...
So we're widening it now from being affected by a finding to having an interest, are we?
Well, item B of subparagraph 2, which is set out in paragraph 11, it is very widely framed. There is an issue involving the new party and the existing party, which is connected to the matters in dispute. Okay. So that's clearly broad enough to catch, as my lady points out, the potential for Part 20 proceedings in the future. But it's also clearly broad enough to catch the potential for a direct claim by the claimant. And in fact, if one looks at paragraph 13, Lord Justice Waller went further. He said, I would go further in accordance with Mr. Maxwell's final submission and accept that if the minors chose at the outset only to bring cases where there was no CMC connection in an attempt to avoid their joinder, but the court formed the view that ultimately minors who did have some CMC employment would seek to obtain compensation from the DTI in reliance on that decision, and possibly some claims handling agreement similar to that agreed in the chronic obstructive disease litigation, so that the CMC were at risk of Part 20 proceedings. In such cases, the court would have the power to allow the CMC into the proceedings. So his lordship seems to have taken the view that the breadth of the power was such that even the risk of future proceedings involving the to be joined party would be enough to give rise to the power to join them. But of course, it then is a separate matter whether or not the discretion should be exercised to exercise that power.
The power comes from subparagraph 2
Yes.
of 19.2.
Yes.
So I think what you're submitting that Lord Justice Waller may be saying, if I can put it like that, is that either and I think you go for B, a person is in, when there's a person in the position of the CMC, either it's desirable to add them in order to resolve all matters in dispute, or there is an issue involving the new party and the CMC, involving the CMC and the mine, whoever it was, which is connected to the matters in dispute in the proceedings, and it is desirable to add them, so that the court can resolve the matters in dispute in the proceedings.
Yes.
Which carries it with it the implication that you can't without them.
No, because that would be a necessity test. And there is a distinction in the CPR between the necessity test and the, so for instance, set aside personal injury litigation with out of time claims. Somebody can only be joined if there's a necessity test met, which is much narrower than this.
My lord is right that you put it under B.
I actually put it under A as well, because the words in dispute have since been interpreted by Sir Terence Etherton, then Master of the Rolls, as meaning in issue, because he too felt that the power ought to be a very broad one, and that's the Pablo Star case, which is at tab 5 of the bundle, Price and the Registrar of Companies.
Well, do you need to take us to anything more in Davies?
I don't. But if I could go to Pablo Star.
Yes, that would be helpful.
2018, first volume of the Weekly Law Reports, page 738. This was a case where the claimant was seeking to re-establish a company on the Registrar of Companies that having previously been struck off, seeking to establish it for the purposes of litigation. He wanted to bring one of the potential parties affected by the litigation related to an ownership of copyright, where it was the Welsh ministers. And they sought to intervene in the registration proceedings in order to apparently correct what they said were some misstatements that the claimant had made in support of his application to have the company reinstated. The court held that was not a sufficient interest in the registration and restoration proceedings to join. But in terms of the width of the power, at paragraph 51, the then Master of the Rolls said, is at page 749, paragraph 51. Sorry, paragraph 50 I should start with. He says, on its literal reading, CPR 19.2a is directed to a situation where prior to the joinder of the new party, there already exists a dispute which is the subject of the proceedings. In the present case, aside from the issues which the Welsh ministers wish to raise if they are joined, there is not and never has been, strictly speaking, any dispute. The proceedings were for the restoration of Pablo Star to the Register of Companies, and the Registrar of Companies consented to the restoration. There is no suggestion that even if the Welsh ministers are not joined, the only other party to the proceedings, namely the Registrar of Companies, would wish to argue that some sanction should apply to Mr. Price, because the court was misled on the making of the restoration order or the making of the variation order, or because Mr. Price was in breach of undertakings to the court. The provisions of CPR 19.22 ought, however, to be given a wide interpretation. The words in dispute ought to be read as in issue. That is consistent with the authority that the court's powers to add a party under CPR 19.2 can exist after judgment, even though in a literal approach there is no longer a dispute. See Dunwoody Sports, Marketing and Prescott. It is also consistent with cases such as Stanhope and Blenheim, in which the court permitted third parties to be joined to an application for restoration of a company to the Registrar of Companies, and for all practical purposes, it was only the intervention of the third parties which put in dispute whether or not the company should be restored. What's
the difference between in dispute and in issue?
Well, The Master of the Rolls seems to have thought it was a lot wider to say it was an issue.
Well, I just don't.
I don't get it either. If my
I suppose the
support, but we ought to be able to work out verbally. I find it very difficult to see what the difference is, but we ought to be able to work out what the effect of the difference in that particular case was, because that's the context in which he said it and applied it.
Paragraph 53.
He did think it was capable of falling in dispute.
Yes, but I'm being rather slow. I haven't grappled with this case, no doubt, as much as I should have. The problem he seems to have identified at 50 is simply a technical one, that there's no dispute until they come into the proceedings. And that's the problem, which he thinks is solved by reading in dispute as in issue. Or have I missed it?
Well, he seems to put it slightly wider than that, because he then talks about also things
I
can
think
be an issue.
55 helps us on the issue dispute bit.
Oh, sorry?
I think paragraph 55 helps us on the issue versus dispute bit, because there wasn't the case was about the restoration, and that was the dispute, and it was going by consent.
Yes.
The issue, which was that, and the Welsh minister had no dispute in relation to that. The issue was the validity of the assignment.
Yes.
And so it had to be an issue rather than dispute in order for Master of the Rolls to allow them in under, I think, B, not A.
I think that must be right, my lady.
That's on my first reading of it.
That seems.
I suppose it may be something which is not an issue on the pleadings. In the
Well, it
case.
wasn't because presumably they wouldn't have agreed to the restoration if they'd thought it was a fraudulent assignment.
Yes. Although they did want to get involved so that they could try and set aside the restoration on the basis.
Of course, but that was consequential on the validity of the assignment.
Yes.
So that's stage 2.
Yes.
And again, formally, for the same reason, it's not ratio, although it clearly is a considered opinion and entitled a particular weight, but it's not ratio. He actually decides it on the basis that it wasn't desirable.
He did. And he decided it on the basis of the fact that there's quite a lot of law about when people can intervene in relation to the restoration of companies, and obviously one doesn't want a threshold which is set too low, because otherwise the world and his wife or husband would be intervening all the time. And he also felt in relation to the second limb of 19.2 that actually the points which the Welsh ministers were raising about how the court had been misled and so forth actually led nowhere. They weren't really points of substance, and so that was another reason why it wasn't desirable to let them in. That was, or at least that was the reason not to let them in under that limb. And if there had been any misleading.
So one way or another, it was a pretty hopeless application.
Yes.
We come back. It's quite interesting when you when we get to the lodestars, which you've referred to.
Yes, the paragraph
60.
60. Yeah.
It's interesting the way Sir Terence expresses that, which is the policy objective of enabling parties to be heard if their rights may be affected.
Yes.
Well, expressing a little bit of the same scepticism about the nobly altruistic motives that your clients have adopted as the judge below, it's you who is trying to bring them into the proceedings, and the highest that can be said of them is they haven't objected.
Well, they didn't object, and in fact, as is recorded in the judge's postscript judgment and costs below, they in fact opposed the appeal below. So they had a position of neutrality in front of the district
Armed
judges,
neutrality.
essentially. Yes, yes, is it armed neutrality? I think that's better than benevolent neutrality. So yeah, it's not a case as in my Lord Underhill's Beresford case, where in fact it was the party joined who was vigorously objecting to the joinder. Here,
No, but my Lord, Mr. Justice Underhill, as he then was, made some fairly general observations about the undesirability of making people bring proceedings against people they don't want to sue.
I'm clearly going to avoid trying to debate with what my Lord Justice Underhill meant, because he's sitting here.
Well, I think I was reflecting
He'll be able to tell you.
what was clearly Mr. Justice Coulson's reaction,
Yes.
and that of, I venture to suggest, pretty well anyone in standard civil litigation, that as a matter of principle, a claimant can't be made to bring proceedings against someone they don't choose to sue.
Well, it's a perfectly reasonable stance, but pretty much anyone, wouldn't it appear, includes the judges below. And it may well be that the power exists. It may well be that there's a debate to be had as to whether it's a desirable power to exist. But that would be a matter for the Rules Committee.
Well, is this appeal really only about whether the power exists?
Yeah.
I'm just looking at
No.
the grounds on which permission was granted, and they're expressed in terms of not having given any sufficient weight to what Mr. Justice Coulson said in Viridor,
Yes.
which is isn't narrowly confined to the question of whether in some theoretical or very exceptional circumstances an order could be made of the kind that was made, or joining a defendant who the claimant doesn't wish to sue, but about whether it be right to do so in principle, which is effectively what Mr. Justice Coulson said. Isn't it? I'm just looking, it's ground
1.3.
1.3.
The difficulty I respectfully submit with that argument, which was indeed, I mean, the case was considered by the judges below. They both considered that Mr. Justice Coulson was looking at a completely different type of case. But the difficulty with that argument is that if the respondents are right on their construction of the rules, Mr. Justice Coulson's statement that the rules simply didn't permit joinder is not a correct one.
Well,
It might need to be refined, but I'm sorry.
no, I was about to say very much what my Lord is about to
It
say.
might
better.
need to be refined, but isn't what Lord Justice Coulson, as he then wasn't, was really saying is there may be a power under the strict words of the rule, but it is inappropriate to exercise it as a matter of principle in a straightforward case such as this.
Well, in fact, what he said was, and I'm looking at tab 4 of the authorities bundle, and I think this is from Costs Law Reports 2016 and 1041. But I'm looking at page 1044, paragraph 9. What he said was, I do not consider that the court has the power to join a party as a defendant in circumstances where the claimant opposes that joinder. And then he said there was no authority for such a novel proposition had been cited. As we submit in our skeleton, Davies hadn't been referred to him. So he does seem to have thought he simply didn't have the power. Now, There's no
taking a
anal-
very narrow view of the grounds would surely allow us to say, well, there may not be a power in the strictest sense, but it is contrary to, it is contrary to principle to exercise it in such a way as to allow a claimant to be to require a claimant to proceed against a defendant they don't wish to proceed against. We often talk about contrary to principle. When you've got a broadly exercised discretion, you can say it's contrary to principle to exercise it in a particular way, and I suspect that's all Mr. Justice Coulson was intending to say. He maybe used the word power.
The answer I can give to that is then it begs the question of whether the principle exists, and that comes back to the rules. And the rules, if given that they specifically provide in the practice direction for the court to order amendments to the particulars of claim, order the filing of acknowledgements of the services, it's certainly that.
Can we just look at that again? In what circumstances that would be a case, surely? Why isn't that directed at a case where the claimant has asked for the substitution or addition of a new defendant?
Well,
have I missed something in the wording?
No, but there's certainly nothing to limit it to that type of case.
No, but if you've got to cover the situation where the claimant does join a new defendant or a substitute defendant, and it's not surprising the practice direction then makes rules as to how you deal with that. But that's completely neutral on the question whether you're allowed to do it when the claimant doesn't want to proceed a defendant.
I mean, I think because obviously I stand down here and you sit up there. The furthest I can take this submission is that it's certainly not possible to derive from the terms of the rules themselves any principle against the joinder.
I think you're right about that.
What one does deprive, interestingly, is a rule against forcing a claimant to join proceedings without their consent. So the Rule Committee have clearly thought about circumstances where consent is necessary, and that's the one they've come up with. But I don't think I can take it any further on this point.
You're being, if I may say so, extremely careful and clear. Yes, thank you.
That is really all I think I have to say. There is the separate ground too, but I respectfully submit for the reasons we set out in our skeleton. It's quite plain the judges below weren't wrong on that, because there's an alternative course of joinder apart from necessity in personal injury cases, which is that set out in 19.45.
For my interest, I can't see any way that the appeal is going to turn on this. But 19.2,
Yes.
Which is where you haven't got a limitation issue, is desirable.
Yes.
19.5, 1 to 3, you know what's coming.
Yes.
Is necessity.
Yes.
What interests me is 19.54 doesn't say whether cases within 19.54 are desirable or necessity.
And indeed, the judge made that point that 19.2
yes,
says it's an addition.
And he was right about it. But it seems to me that the position has got one added twist to it, which is that, of course, if the judge under 1954A directs that Section 11 shall be disapplied, there isn't a limitation problem anymore. And so there is a sense, a logic, or there would have been a logic in saying, and in such a case, the test is desirable. But where you've got where you're under, as we are, 19.542B, issue shall be determined at trial. What's the answer?
Well, I have to say it's taken me back to seminars many years ago where one debated issues like Ronvo. It has that sort of quality to it. It seems to me the answer lies in the fact that actually the supposed distinction between the discretion under section 19.2 and the type of discretion the judge is exercising under 19.5 is actually really illusory if one accepts that 19.2 has the breadth of reach in terms of desirability, which the Court of Appeal said it had in the Davies case and in the Pablo Starr case. So, in a sense, whether consciously considered or not, when approaching 9.5, a discretion to join is only likely to be exercised if it's desirable in terms that would also satisfy 19.2.
Okay. And then supplementary, if we take it at the most favourable level for you, which is desirable,
yes,
how can it be desirable to join a party as defendant and force the claimant to sue them when all the available information indicates that, at least so far as the great majority of her complaints, she's statute barred?
Well, it comes back to the perspective from where one's looking at desirability from. If one's looking at it purely from the perspective of the claimant, then she may say that's not desirable. And that's an argument to be made before the judge in relation to the exercise of discretion. There are other things which are desirable about having the defendant joined as a defendant. For instance, if you look at it from the perspective of my clients having to use CPR Part 20, which is of course an option that was available to them and is available to them, puts them in a position where they have to take an adversarial position against the defendants in circumstances where they don't have the claimant's evidence as to how strong or not the case against the defendants is.
It's very commonly pleaded, isn't it, in Part 20
is.
cases. I'm not in a position to prove what the claimant says, but if they succeed, you'll be liable alongside me, and I want contrib. That's often seen.
Very commonly pleaded, and I accept that's open to them. But from their perspective, less desirable than a process which brings the parties in real dispute with each other here, because this case, at the end of the day, can only succeed if there's negligence.
But this is Never Never Land. This is adding another Never Never Land. Unless you say you do not want an indemnity from the dentists, we're dancing around on a pinhead. We've got a claimant who actually doesn't want to sue the dentists, and you're hedging your bets. I don't mean that pejoratively, but you are hedging your bets because you've pleaded that you could join them, and you've accepted again today. And anyone with experience of this sort of litigation, as you have just accepted, accepts that it's absolutely standard form, and that's what I almost said should happen.
Well, I would say could happen.
Yes, but because it's your choice whether you want to sue them.
Yes.
It is, but doesn't that impact back on the primary argument? It's the claimant's choice as whether she wants to sue them.
Well, ultimately, where there's a dispute between what the defendant wants and what the claimant wants, obviously it's for the court then to arbitrate that dispute, which is what we say happened below. But I mean, I can't really say more than that. There is Part 20 is availability. It is available. My clients have taken the view that it's less desirable than Part 19. In fact, it's dancing on the pinhead from all directions, really, because in practical terms, if the dentists do end up being joined under Part 20, actually, apart from the Section 33 issue, which might be viewed as rather technical in this case, the claimant will stand in exactly the same position, in a sense, because if it all goes wrong, in theory, she carries the risk for the costs of the added Part 20 defendants. In practice, she doesn't carry any risk because it's a Quox case. So it could be viewed as dancing, as dancing on the pinhead all round. But there are differences in terms of desirability from the point of view of my client in relation to section CPR 19 as opposed to 20. It does mean they're not stuck as piggy in the middle. It does mean they're not having to advance a case against the defendants, adopting a case they know not the strength of it.
But you don't have to. The standard pleading is, but if they're held liable, they claim an indemnity or contribution for you on the grounds that A, you were negligent in so many of the respects as the claimant may prove.
Yes, it's certainly a standard pleading. In my experience, it rarely helps much in terms of costs. But,
well, you can protect yourself. I mean, I know Quox makes it more complicated, yes, but you write letters in advance saying we're only doing this because you're being so beastly to us, and so on and so forth. And
yes, one can certainly try all those things.
Yeah.
As we say, brings the parties who are really in dispute to the central issue in this case is whether the dentists were negligent, and the evidence on that's going to come from the dentists and the claimant one way or the other. And CPR 19 is a way that it can be done, and the courts below have decided is the right and efficient way to deal with it in this litigation. I really don't think I can, unless I can help.
You've been extremely helpful. Thank you very much indeed. I think we'll just rise and see where we want to go from here. Mr. Collins, you'll probably have observed that we've taken on board the points in your helpful skeleton argument. And you may wish to make your submissions short. There are really 2 points on which we would be grateful specifically to be addressed, though of course you can say anything else you wish. The first is whether you accept that formally the power in Rule 19.2 is entirely general, and what the real issue is about is whether, in principle, it should be exercised in such a way as to join a defendant against whom the claimant does not wish to proceed, save possibly in circumstances a very long way this, such as the GLO context and so forth. The second one is rather related to that, which is we would be assisted by knowing the precise basis on which you seek to distinguish or deal with the 2 cases on which Mr. Warnock, in his admirable submissions, sought to rely. Does that give you an indication what we'd like to hear you about?
It does. I'm going to do my level best not to try the patience of the court. There's one other aspect of this case which I'd be grateful for the opportunity to make some submissions on, which is the slightly broader background, because we look at the rules in the context of a detailed decision within this claim, but the way in which it arises in this claim may be of some assistance to the court. I'm
not formally going to stop you, but Mr. Warnock was very economical and went to the issues of law. Speaking for myself, I found helpful that part of your skeleton argument which gave us a context which I didn't have up to that point, but I'm not really sure you, for myself, my lord and my lady will speak for themselves, that you need to add to it.
I agree.
I agree, and we've got the benefit of your updating skeleton as well.
There's a yet further update just from the last couple of days,
yes,
which is that Hughes and Rattan, the case which I indicated,
yes,
was awaiting a decision on permission
yes.
to appeal to this court.
Don't keep us on tenterhooks. It got permission.
It's got permission, so that case is coming to this court.
Yes.
All that does really, and I won't go to the detail that I was perhaps thinking I might do, having heard the way that your lordship has addressed me on it. This is a skirmish within a wider set of issues between claimants in dental negligence cases and the indemnity organisations.
Yes. Yeah, well, we as I say, your submission, I think the judges below were a bit puzzled. They couldn't see what was going on.
That's why I wanted to
absolutely.
deal with it, but if the court has it, then I don't.
We are no longer puzzled. We see exactly what's going on, and we understand both parties' interests in relation to it.
Yeah, I mean,
but
I'm sorry. Well,
yeah.
It's dancing on a pinhead in one respect, but the dance, the gavotte, is against the backdrop that you've set out.
Yes.
Absolutely. The argument at times appears to be, one asks oneself why one's arguing about it. It's only when one sees the wider context. And
well, I think we have really now got the wider context.
To both parties.
We have now got the wider context. We see the importance of it, but ultimately it does come down to a question of law about the proper approach to the exercise of the discretion, if you see it that way.
It does come to a question of law. There's a difference between us, I think, insofar as Mr. Warnock characterises the appeal as an appeal against the existence of the jurisdiction, but not the exercise of the discretion. And I put it rather differently than that. It's the approach that is taken to the application of the rule in the first place, which is in issue. It's an error of approach which is encapsulated in effect by the first question that, my lord, you asked me to address you on, whether we accept that formally there's a general power in 19.2. And plainly, on the wording of the rule, it is broad. And the way that we would put it in response to my lord's question is this, that the respondent's proposition that the court can properly exercise this power, worded in general terms, in a specific way, so as to require a claimant to sue somebody she doesn't want to sue, is wrong. And it's wrong as a matter of principle.
Yeah, well, that's what I thought you would say, but you have confirmed that you have said it. Yes. And it follows from that with all respect to him, Mr. Justice Coulson may have put it wider than he need and wider than you would when saying there is no power. If by no power he meant no jurisdiction in the formal sense, that goes rather too far.
Yes.
By the way, we don't, in my court, I don't approve of, as he then was. We all know who everybody is and what's happened to them since. Yeah.
That saves me some words, at least, my lord. So, depends what one means by the word power. Plainly, there is a jurisdiction provided by Rule 19.2. Well, one starts at 19.1 to add claimants and defendants as parties to the claim. So, in one sense, there is a power. But it can't be exercised in all circumstances, because there are some circumstances where, as a matter of principle, it would simply be wrong. So, there's perhaps two different ways of looking at it, and it perhaps doesn't make too much difference whether Mr. Justice Coulson was talking about the existence of a jurisdiction, which exists in the broadest terms, or a power to exercise that jurisdiction in a way which is contrary to principle.
As you say, it doesn't matter for at least two reasons. One is it may ultimately be a distinction without a real difference. Anyway, we're not bound by how you put it, so we have the luxury of rephrasing it if we wish.
Yes. My lord, I'm just pausing then to work out which parts of my speaking note to strike through, and it's it's a fair bit of it in light of
That's what we hoped and expected.
The comments that the court has made. So we start, of course, with the proposition that Mr. Justice Coulson was right to say that a claimant can't be made to pursue a claim against someone if she doesn't wish to do so. The answer to it, and to the same sentiment in effect which my lord in Beresford expressed, derives from what Lord Justice Waller says in Davis, and the submission, of course, which I make about Davis is precisely the one that my lord, Lord Justice Stuart-Smith raised, which is that this is a GLO case. It's a decision about excluding issues from a GLO, whether issues relating to the contractors should be in or out. And the court's powers in relation to group litigation give rise to quite different considerations than one has in a claim of this sort. And indeed, I can just turn it up, it's tab 3 in the bundle. I can just look at paragraph 15, please, on page 3238. There's a citation from a judgment of Lord Justice Steyn in a case called A.B. and John Wyeth, and it's the quote next to C by the upper hole punch. The judge's procedural powers in group actions are untrammeled by the distinctive features of the adversarial system. The judge's powers are as wide as may be necessary to control the litigation fairly and efficiently. So we are in a different ballpark, and part of the reason for that is that what the court is trying to do when making a GLO and identifying what the most effective terms are for the GLO is precisely to sweep up other claims which may arise.
Yes, but the strength of Davis from Mr. Warnock's point of view is that although the context may be the GLO, you still have to use the mechanism of Part 19.2.
Yes.
Why is that not a problem for you?
It's not a problem because I've already accepted that the wording of 19.2 is put in very general terms. And it may be that I went a shade too far in my skeleton by saying you can never use this in circumstances where a claimant is brought into litigation, because I hadn't turned my mind to a group litigation order.
So you may have just found where exceptionally it could be used.
And it's not at all unfamiliar that a principal throws up unexpected circumstances as the law develops, where one thinks it might need to be, where it may need to be applied differently than one had first envisaged. So the power in 19.2 is the gateway to the management of the issues as identified by Lord Justice Waller in the group litigation context. Precisely because, or amongst other things precisely because, the court is, as he puts it, untrammeled by the distinctive features of the adversarial system. It's not simply up to the parties to choose what issues they plead, because the court is looking at future claims and how to avoid them.
I think it's right. Wyeth was in the early days of developing mechanisms for dealing with multi-party actions, and I think is before GLOs were in fact invented. Because I think it's Mydell. It's either Mydell or it's your.
It's benzodiazepines.
It's either benzo or Mydell. Anyway,
I assume my lord was in it, as he was in most of these.
I think I was, but I can't remember. I can't remember which it was. But the untrammeled. So now we've got a slightly more formalised structure, but the principle is the same. That GLOs, as we now know them, are devised to set up to deal with issues which cannot sensibly be dealt with on a single case basis.
My recollection is the same, that GLOs in their present form postdate this, but that there were procedures, I forget exactly what form they took. I'm not sure it wasn't. I'm not sure Sir John Donaldson didn't make some general practice note of the kind he did, saying in multi-party actions, do what you like. It really doesn't matter. The principle, you say, apply, stated by Lord Justice Steyn, you'd say applies in a GLO situation.
Yes, the normal rules of inter partes litigation are different in the context of a GLO. In 1992, for reasons which were developed as perhaps rather more by the bench than the Rules Committee, if I can put it that way. Currently, we have part of Part 19 which deals specifically with it. But the point is the same, which is that you are in a territory which does not immediately lead to the conclusion you can't possibly make this claimant sue that defendant, because the rights of the parties to determine the course of their own litigation are more circumscribed than they are in the sort of case that we're dealing with at the moment. The argument, as it appears here, is plainly focused specifically on the specific issue of how best to manage the GLO. It looks from reading the judgment as though the possibility of using 19.2 came from the bench, and that counsel for the CMC.
So he was rather disobliging about counsel for the CMC.
One of those days, as it were, and difficult to see how much assistance the court got in terms of any potential wider ramifications. It seemed pretty clear that the court was not looking at anything other than group litigation and how best to manage it. So Davis doesn't begin to, in our respectful submission, do any damage to the robust and clear assessment of the position from Mr. Justice Coulson and from my lord in the Beresford case. We're agreed, I think, that it's obiter in any event, even if it weren't distinguishable. Pablo Starr doesn't assist us really either in our submission, because again the context is very different. It's a case about a statutory application to restore a company to the register. So there's consideration about the extent of the jurisdiction to join third parties to be heard in the context of restoration proceedings, but they're not suing each other. Not in the context of that claim. And we can see that, if I can ask the court to turn, it's tab 5. And if we look at paragraph 60 on page 751, which is the passage in particular that the respondents rely on, I'll come back to the first part and the lodestars. But about 4 lines down, there are important practical considerations for strictly limiting the circumstances in which third parties are joined to applications to restore a company to the register, and they apply equally to applications to set aside an order for restoration. Many third parties who perceive their interest may be indirectly affected, so on and so forth. I don't need to read all of it out. But the question for the court was not whether a claimant is entitled to damages from a respondent. It's whether the court had been misled, in effect, in making the restoration order. And the idea of enabling the ministers to be heard in this statutory application, perhaps ill-conceived as the application on the facts may have been in this case, but the idea of being joined in that way in this kind of a case is quite different from requiring a claimant to bring a claim for damages against a defendant. And it may be that that's another possible explanation for the Master of the Rolls is for the fact that he felt the need to try to identify whether there's a difference between in issue or in dispute, because it's not, strictly speaking, an inter partes dispute which he was faced with. It was rather a case in which the ministers felt there were matters which the court could or should take into account, and they wanted to be heard on that issue. And it may be that that's another explanation for the Master of the Rolls taking the approach he did. The word lodestars has been alighted upon by the judges below, and again in the respondent's submissions here. But there's no suggestion that what he describes as lodestars are the test for interpreting 19.
I don't even know what a lodestar is.
It's I took it to mean the point, metaphorically, the point by which one takes one's guidance.
Yes, I suppose that must be right. It's a, yes, isn't there a lodestone? Perhaps.
Yes. don't know what
It's to do with magnets and compasses.
It is
Yes.
to do with that, and I think it's one uses a
education,
lodestar to find one's way, whether it's because it points north or something along those lines. I think
I
that
shall look it up
It's
afterwards.
a personal thing that serves as an inspirational guide.
Yeah, but I'm digging even deeper than that. I want to know why it means that, but it doesn't matter.
It was a star that was used to guide the course of a ship, especially the pole star.
My lady has confirmed what.
very, very grateful for that. And a lodestone might point one north if it's magnetic.
It's a magnet.
Yes.
Yes.
So it tells you what direction to go in.
Yes.
Is perhaps the a simple way of putting it. And of course, those matters are lodestars. As far as it matters, it doesn't say they're not the lodestars. They are just two of them. And of course, the overriding objective is always a lodestar in any decision that the court has to take about litigation, to some extent. Those were matters which the Master of the Rolls thought were important in the context of that case. They don't give us an answer in this case. So, when one understands Davis and Pablo Starr in their proper context, the question one is then left with is what principles are applicable when one seeks to interpret CPR 19.2, and I probably ought to touch on 19.5 as well. I'll do so very briefly. If one derives, and we say one does derive, a principle that it can't be desirable to force a claimant to issue proceedings against another party, then we say, of course, both judges below fail to recognise that, and that's an error of law, an error of approach, because they couldn't have granted the respondent's application or dismissed the appeal if they'd done so. I can assist you on the detail of 19.2.2 A and B if it assists, but you've got my submissions in writing, and I suspect I've not got a great deal to add to what I've
I think we're content to go with those. Thank you very much indeed. Yes.
There was some discussion this morning about what was desirable for the claimant and what was desirable for the defendant. And of course, what this court must consider, and any judge looking at this, is what is desirable in the interest of justice. So it is not a question of practical or strategic benefit for either side. It's not even in this context a question of efficient case management. We haven't got to that point yet in my submission. It's a question of principle, and I've already addressed the court on what we say the principle is. And just to be clear, can I just take the court to the part of the district judge's judgment which we say is the error of law, or makes it easiest to find the error of law. So it's in the core bundle, tab 10. We have the judgment. It's right at the end on page 130. Paragraph 32, the errors that we say the learned judge fell into are encapsulated in this paragraph. There is clearly a dispute between the claimant and the proposed defendants, the four dentists here. We say that is wrong. There is no pleaded dispute. I accept submissions of Mr. Piper, who appeared for the respondents below, but the Welsh Minister's case, that's Pablo Starr, overtake Milton Keynes and Viridor. That means I do not have to consider the issue of whether or not the claimant consents to the addition of the four dentists as defendants on this occasion. We say it was essential for the learned judge to consider that. The stress put on the interpretation of 19.2 referred to as a lodestar is effectively allowing the parties to be heard. I won't read all of it out. And then it says in the last sentence, the court, HHB does not deal with, the courts do not deal with or are concerned by the consent of the claimant on that occasion, and we say that is wrong for the same reasons. I said I'd just touch briefly on 19.5 because we've got most of the allegations are out of time, some are in time, but most of them are outside the primary limitation period. And as the court will have seen from our submissions, it's no surprise that there's a stricter test where limitation has expired, and if there's no way round limitation, then that's why you have the requirement of necessity in 1952 and 1953. Nobody suggests we're in that territory. 1954 is there, of course, to deal with the complexities of section 33. So if it's clear to the judge hearing the application that it's right to extend time, then we don't need the stricter necessity test. But the rules, of course, allow for cases like this one where the judge says, well, we'll have to leave this to the trial judge to decide it. And it makes the case, we say, all the stronger when one thinks of an example such as this. And this is an example of why it's an important principle that one shouldn't force a claimant to bring proceedings against her will. To force her to bring proceedings where she knows that there's a decent chance she's going to lose on grounds of limitation would be an extraordinary proposition. But if one has a decision that limitation needs to be put over to the trial judge, that can't leave the question of joinder to be addressed on some different or vaguer or more lax basis than if we were under 19.2.2. The judge has still got to undertake a rigorous assessment of whether it's desirable to join the new defendants. A sense in which, although desirable is a word expressed as a test in 19.2, a judge is always asking whether it's desirable in the interest of justice to take whatever the decision is.
Is this a way of putting it, or is this overcrude? 19.2 has always got to be satisfied, but in certain circumstances, in principle, in certain circumstances, there may be a still higher hurdle under 19.5.
Yes. Yes. It's perhaps a bit circular. So it's got to be desirable to join the defendants before you can join them. Well, it can't be a lesser test simply because you're in 19.5.4. Yeah. 19.4 there is simply to provide for circumstances where there may be a limitation defence and it needs to go back to the trial judge. And the reality, of course, is that overwhelmingly what the Rules Committee must have been thinking about in all of this is applications by claimants to join defendants. All of these rules are perfectly straightforward in that ordinary set of circumstances. They're much harder to understand in circumstances such as this, and the reason for that is, as a matter of principle, this sort of application is simply wrong. My lords, may I just turn my back for a second to check there's nothing I've missed out which those instructing me are concerned by. My lords, my lady, unless there's anything further I can assist with.
No, thank you. That's also been helpful. Mr. Warnock, do you want to add anything by way of reply? No. Well, we will reserve our judgments, though hopefully not for very long. With two such experienced counsel, I'll give myself the indulgence of not explaining the hand-down procedure, with which you're very familiar, but I do want to say that we have been greatly assisted by the original written submissions and by the succinct and cogent way in which the oral submissions have been advanced. Thank you.
All right.